Good day, ladies and gentlemen, and welcome to your Employees Benefits broadcast. At this time, all participants are on a listen-only mode. I would now like to turn the conference over to our host, Ms. Lee Riley. Ma'am, you may begin.
Thank you, and good day, everybody. Welcome to the Foley and Lardner Employee Benefits broadcast. Before we get started with the substantive portion of our program, I just want to run through a few housekeeping items for you. First, if you have any problems accessing the PowerPoint on your screen, please call 866-493-2825 and somebody will be able to help you. And if during the presentation there's any problem with your audio, dial that number or stay on the line and dial *0 and an operator will come on and assist you. We will try to leave some time at the end of the presentation for questions and answers. And if you have a question, at the top of the screen, you'll see a Q&A tab. Click on that. A drop-down menu will pop up. Type in your question. And again, if we have time at the end, we will share the question live for the audience and give you an answer. If we run out of time, however, we will get back to you separately. If you want to maximize the PowerPoint, hit F5 on your keyboard. And if you want to print this presentation, on the lower right-hand corner of your screen, there's a little printer icon. And if you click that, hit Convert to PDF, you can then print that PDF and take the presentation with you. So our topics today, we're going to talk about three things. Normally on our employee benefits webinars, we talk about new regulations. And while our regulators have been relatively quiet in the last few months, our Supreme Court certainly hasn't. So we're going to talk about two important cases today that affect employee benefits. Our Chicago partner, Mike Wooliver, is going to talk about the Cigna case. And our Los Angeles partner, who's one of our employment and labor partners, John Aislos, is going to talk about the Wal-Mart case. And in between that, Greg Duge, our partner in Milwaukee, is going to talk about some 409A issues that we still see employers struggling with, even though we're a few years beyond the final 409A regulations. So starting us off today will be Mike Wooliver talking about the Cigna case. Mike?
Thank you, Lee. The Cigna case, one thing everybody agrees about the Cigna case is that it's a very, very important case in terms of its impact on ERISA, but there isn't consensus as to why that is. On this slide, I've set forth a couple of headlines that I cropped out of a number of articles that have been published about AMARA since it came out a couple of months ago. And if you just read them carefully, you'll see that they're basically inconsistent. One's focusing on the fact that the SPD is not important. The next one suggests that you can get remedies for misleading SPDs. One suggests that there are new remedies. The other one suggests that the new remedies are in dicta and therefore they're not particularly important. So where are we on all this stuff? That's what we want to talk about today. The basic holdings in AMARA are really fairly straightforward. First of all, in what I think is a very important ruling, but not that important, as we'll see as I go through my discussion, the court basically said you cannot sue for benefits under 502A1B based on the language of the SPD as opposed to the plan. So when there's a conflict, the plan controls because the SPD is not the plan document. That's a fairly significant change from where we were. On the other hand, what the court takes away, it sometimes gives back, because the court went on to say that you might be able to get the same remedy, or at least appropriate equitable relief, under 502A3 when there is a violation of ERISA and the applicable level of harm is shown. And the third important point here in clarification that came out of the decision is that there are different standards of prejudice, or the different levels of harm that you have to show in order to get equitable relief under A3, and the level of harm that you have to show really is directly tied to what you had to show in equity back in England in 1650, which makes research really interesting. Now, the real implications of AMARA for plan sponsors and how these rules are going to affect us going forward are far less clear than the holdings of the court. and that's what we're going to spend some time talking about today. Before we do that, I want to give a brief overview of the case. It's a fascinating case, factually very simple, but legally very complex. The facts are basically that in 1997, Cigna decided, as many companies did at that time, that it wanted to convert its existing defined benefit plan into a cash balance plan using the greater of A or B cash balance formula that many plans did at the time. The other key fact is that they announced this in a newsletter in November 1997 that was sent to all of their employees. And then throughout 1998, with the plan becoming effective 1/1/98, they continued to provide further information to the participants about the plan. And one of the reasons they did this is that in 1997, when they announced it, they didn't have a plan document. The actual plan document was not signed until December of 1998. So obviously, as further information evolved, they sent out information and clarification in a number of communications. Then in 2001, also not unusual in this period when people were challenging the conversion of these plans, a class action suit was filed on behalf of all Cigna employees, stating multiple grounds for finding that the plan was invalid and asking that their old plan, their old DB plan, be put back into place. The district court's liability opinion, and it came after a trial, and it's very unusual in these kinds of class action cases. Normally, they're settled or there's a summary judgment or resolved through a motion to dismiss. But here there was actually an extensive trial and a significant record developed. And the court issued a very extensive, lengthy, well-reasoned, detailed opinion, 73 pages long, in which it basically said there's nothing wrong with the cash balance plan, technically. It was lawful. It didn't violate the age discrimination rules. There was no impermissible backloading. There was no impermissible forfeiture. Basically, as prepared, the plan was perfectly fine. But it did notice, based on the record, that Cigna hadn't really provided the 204H notice of the benefit reductions that were going to occur from the conversion. They didn't disclose certain material modifications, even though they were required to in their summary plan descriptions and SPDs. And they also failed to disclose the extent to which optional forms of benefits were being subsidized, which was required under IRS regulations. The key finding, however, though, that these errors on Cigna's part were not harmless errors. That Cigna had knowingly misrepresented the terms because it was very concerned about the backlash that would happen if it actually told people what was going on. Cigna tried to dig out of this hole by saying, well, our November 1997 newsletter was our 204H notice, except that that notice included statements like, the new plan is going to significantly enhance your retirement. You're going to build benefits faster than under the old plan. And each dollar of credit you get under the new plan is another dollar of retirement benefits. Now, it turns out through the record that Cigna actually knew that because of wear away, those statements weren't true. Further, it instructed Mercer, its actuary, not to prepare any comparisons of old or new benefits, even though when they showed some preliminary informational documents that they were going to show to participants and ran them by some participants for comments, the standard comment was, well, all I really want to know is, am I better off or worse off? When it went through, it also made a finding that the SPD was deficient, not only the original notice, but the subsequent notices that were given, because they also failed to talk about wear away and failed to talk about some of the retirement subsidy issues that the court found problematic. Cigna argued that, oh, well, there may have been violations, they may have been willful, but nobody was harmed. I mean, nobody's showing that anybody was hurt here. I mean, we have the right to change our plan. We can do whatever we want, and therefore, where's the harm? In response to that, the court said, no, we're going to follow the Second Circuit's likely harm standard because that standard is more consistent with ERISA. And that standard basically says if you can show some kind of act that likely would have harmed plan participants, then you're okay, and the employer can rebut that by showing harmless error. Following the trial and finding of liability, the judge said, well, I've now created this record of how you've wronged the participants, but I'm not quite sure what I should do about that. And so he asked the parties to submit parallel briefings to talk about what remedies are important. And clearly the judge was very concerned because he said there's really just not out there, a lot out in the case law that tells me what I should do when faced with this problem, and it's going to have huge implications on the participants or Cigna, depending on how I decide to address this issue. The court really had two issues that it had to deal with. One, a prior judge had certified the class as a class action under Rule 23b-2, which basically is a rule that allows certification of class where the principal remedy sought is injunctive relief or declaratory relief, and monetary relief does not predominate. And here what people were looking for was additional benefits, which is like monetary relief. Well, the court found that that was okay, that the certification under B2 was fine, because the awarding of benefits based on the declaration that the plan was invalid and the old plan, for example, was put back in place was incidental to the injunctive and declaratory relief being sought by the participants. The second hurdle the court had to face is it had to figure out how to grant relief either under 502A1B or A3, because those are the exclusive remedies that participants have when they're making claims for benefits. His analysis was complicated by the fact that normally what you would do if there is an improper 204H notice is to, make the notice ineffective, continue the old benefits until the proper notice is given. But here, because it was a conversion of a plan that was then frozen, and that the errors that were being alleged related to the new plan, invalidating the new plan and putting them back into the old frozen plan wouldn't have given any relief at all. And it was also, the court was struggling of whether it had authority to invalidate the new plan when he had found that it was not lawful, it was entirely legal. The problem was entirely related to the fact that Cigna had made these material misrepresentations about what the terms of the plan were in communicating with plan participants. What the court did is there was existing authority in the Second Circuit, as there were in many circuits, saying that effectively the SPD is a contract, and if there are benefits in the SPD that are not available, you can give those benefits under 502A1B. You can basically reform the plan to conform with the misleading disclosure. And that's exactly what the court did. And the court then talked about the A3 option and said, well, I'm not going to talk about A3. I'm not going to decide whether it's available or not, because first of all, if I can find an A1B benefit, there isn't an A3 benefit and I don't have to deal with it. And second of all, I'm very concerned that the Supreme Court, starting with the Mertens decision, which came out in 1993, has severely curtailed what I can do. It's basically, there's questions in my mind of whether I can actually give people additional benefits under A3. So I'm going to make my opinion under A1B. After deciding, how he was going to approach it, he went back through all of his prior findings and said, well, I really can't order any relief under 204H for the reasons I just mentioned. There isn't an old plan and there was no violation of the new plan. But I can order relief because of the misleading statements in the summary of material modifications and in the SPD. And I also think, when I think about it, that the best way to do that is to ignore the benefit structure, the greater of A or B structure that's in the plan is drafted, and direct the plan administrator to pay benefits under the cash balance plan as if the cash balance plan was an A plus B benefit structure. Because that eliminates any issues of wear-away, eliminates the opening balance issues that had been identified in terms of whether or not the early retirement subsidies and things needed to be included, and it just cleans up everything. And then he also, for one final time, said, because I can't get you a remedy under 204H, plaintiffs, I can't really put you back into the old plan. The court was then appealed by Cigna up to the Second Circuit. The Second Circuit looked at it, said, looks good to me, issued a summary opinion, and then both sides filed petitions for certiorari. The petitions filed by the plaintiffs focused again under the issue of whether or not they really did have a remedy for the 204H violation, because the plaintiffs really wanted to go back to the old DB plan, which everybody then knew was a much better plan than the cash balance plan. And Cigna said, well, there's a split in the circuits. Likely harm is in the Second Circuit, but a lot of other circuits have detrimental alliance or other levels of things, and therefore we think you should take it because of the conflict in the circuits. Supreme Court said, yes, you're right, Cigna, we'll take your petition. There clearly is a conflict in the circuits on the issue of in order to get this kind of relief, what kind of harm do you have to show? And we're going to hold in abeyance the whole issue of 204H until we see where this case goes. When the case was decided, however, it wasn't decided on the basis of the level of harm necessary to get relief, because during the development of the case at the Supreme Court level, a light bulb went off in Cigna's mind, and it said, wait a minute, where does it say that you can get relief for a rewritten or reformed plan under A1B when you read A1B? And an 8-0 majority in the Supreme Court said, you're right. There is nothing in A1B that suggests that a court can reform a plan to provide for benefits other than benefits as set forth in the written plan document. That's what the court's job is to do, is to interpret the plan, not to rewrite the plan. And the court went on, and this is where the whole issue of the impact on the SPD is, the court went on to reject an alternative argument that the Solicitor General made on behalf of the Department of Labor that basically said that the plan document includes the SPD, or the SPD is part of the plan document, and the simple remedy is to merely award benefits in accordance with the summary plan description. And the court went into an extensive discussion of why the SPD is not the plan document. Its whole purpose is to be a summary, not the plan document, that it would create all kinds of legal nightmares if, in effect, the nuances of complicated plans had to be fully described in a summary plan description, that the plan is the product of the settlor or employer plan sponsor, that the SPD is done by the administrator for different purposes, and it's just not appropriate to award benefits under A1B because of consistent with an SPD when there's a conflict with the plan document. A 6-2 majority then went on to discuss whether relief might be available under A3. Again, the court has expressly declined to look at the A3 issue because it had found relief under A1B. And the Supreme Court said it's likely that they would then look at A3, and therefore we should give them a little thought on this process. And the majority then went on to say as well that the concern raised by the district court about the narrow scope of remedies available under A3 were unfounded because the whole purpose of equity is to make sure that you got a remedy when there's been a violation of a right. And went through an important discussion of both Mertens and Great West, or two earlier Scalia opinions in which the court were the basis for the district court in this case concerned that the remedies available under A3 were very limited, and narrowed those down to a point where they have far less importance than they have been given by courts in the past few years. The court went on to say that a suit by a beneficiary against a plan fiduciary is just the kind of lawsuit that was always brought under equity and therefore appropriate under A3. That what the court had effectively awarded were affirmative and negative injunctions, and those are equitable remedies. And that equity courts have great flexibility to formulate additional remedies as necessary to really provide the proper relief. The court went on and then talked about three specific remedies that the district court might consider, assuming it concluded that A3 relief was available, to get to the A plus B relief that the court had concluded was appropriate in the first place. The court said there's reformation, which can be done for a false and misleading information under an equitable principle as opposed to the limited nature of the statutory rights under A1B. You could say that Cigna, once they've told the people what the plan benefits are, is a stop to argue it's something else. Or, and most importantly, it said, and there's this equitable relief of surcharge where you can actually get monetary compensation for a trustee's breach or to prevent a trustee's unjust enrichment. The court then turned to the whole issue that they brought the case over or accepted the case over about what level of harm was necessary and said all of the lower courts were wrong, that in order to determine the right level of harm, you've got to look to the specific equitable remedy, because ERISA doesn't say anything about this, and therefore if we're going back to equity and saying you get reformation or you get surcharge or you get some other equitable remedy, you have to look at what the court required as a level of harm in each case that you're relying on to get to the right answer. So that if you have detrimental reliance, that is the standard for estoppel, but it can't be the standard for other things because in surcharge and in reformation, the different standards were applied at equity. Finally, the court did not tell the district court what to do. It said, we just got a partial record here. The court didn't even consider any of this. We're just going to send it back and to think about what remedies are available, whether A3 is really appropriate, particularly now that because of the 204H violation, and make some further determination as to what the right remedy is based on your findings of liability. As I said, that portion of the opinion was not joined by Justice Scalia and Thomas, who in their concurring opinion authored by Scalia made it very clear that anything that the court says after there's no right under A1B is irrelevant because it's dicta. And Scalia seemed to forget the fact that dicta was really the basis of all the problems in the Merton decision, a 5-4 decision, which basically says you can never get monetary relief under A3, contrary to the dissent in Merton's, which was argued other equitable relief as used in A3. The whole purpose of A3 is to give the courts power to remedy violations and therefore to read it so narrowly as improper. Takeaways on all of this. First of all, I think the most important part of this ruling is the 502A3 ruling, not the ruling that you can't bring SPD claims under A1B, for a number of reasons. Merton's was decided in 1993, and since then, based on, again, dicta and Scalia's opinion that you can never get monetary compensation in under A1 or A3, a number of participants were denied remedies even when there was a clear finding of fiduciary violations. And I think that Scalia was wrong, and more importantly, the lower courts were wrong in saying that there were no pseudo-compensatory remedies under A3, and that the dissent in Merton's on that point was right. And therefore, we're back to a more balanced view of A1B being your clear case for getting a benefit, and A3 being your right to get that same benefit if there's some equitable violation that keeping you getting your benefits under A3. So again, I think that's a very important decision, and I think it also will help employers because there have been district courts as well, including a case that's currently before the Seventh Circuit, that have read that dicta about monetary relief in a way that it precludes plans in some cases from getting appropriate reimbursement or restitution when excess benefits have been paid. So I think it's a good decision on that point from both sides. What is less clear is how far a participant, the courts will take the Amara ruling and saying that you can make people whole. On the one hand, all that was necessary in Amara was a finding that there had been a violation of ERISA, namely that a failure to comply with the disclosure requirements of ERISA without any linking of that to actual harm. And they basically said that failure to disclose was actual harm. The violation was the harm. That suggests a very low standard, at least in the case where you have a very significant breach. My guess is that the courts will actually use a standard here as they have in the past in ERISA cases when applying equitable remedies, and that is the greater the fiduciary breach, the lower a standard of harm you're going to have to show to prevail. Also, the facts of Amara are pretty bad. I mean, Cigna knowingly lied to its participants because it didn't want to tell them the truth. It's not clear when the violation is unintentional or not as material what a court will do with this. Now, the scary part there is there have been at least 2 amicus briefs filed by the Department of Labor since Amara that suggest that even a lack of clarity in your SPD may be sufficient to allow a claim under A3. One specific case involved a situation where a participant asked for prior approval, pre-authorization of a treatment, got the treatment, and then the treatment coverage was denied. And in that case, the Department of Labor suggests that, having a call center that doesn't give a binding authorization when you don't tell people it's not binding or don't tell them how you can get a binding authorization may be sufficient to get A3 relief. And that's kind of scary. And so I think that the decision itself is good. It gets rid of Mertens, but we really don't know where the lower end of the decision is and how much use people will be able to make of this case going forward. Some of the commentators have made a lot of the fact that the discussion of the A3 remedies is only dicta. I sort of don't take a lot of comfort from that. The Department of Labor's amicus briefs go into a great deal explaining why it's not dicta. And more importantly, as we know from Mertens, lower courts, when a black and white rule is laid out in a Supreme Court case, even if it's dicta, it gets cited by the lower courts. I also think that there may be impact on insurance here because the remedy of surcharge, I think, significantly exposes fiduciary to personal liability, and that hasn't been factored into current policy structures, benefits, and costing. I think that's going to be an issue. The standard of harm, again, I think the issue here may have effect in terms of what we do, particularly in the class action area, but that really will depend on whether there's a real standard of harm or that we have traditionally looked at, or whether or not all you need to show is a violation of ERISA by a fiduciary to get recovery. I think the ruling with respect to the scope of 502A1B is actually a good ruling. It creates much more symmetry within the statute. It's going to eliminate a lot of nuisance suits where people have pointed out simple discrepancies between the SPD and the plan, and where the courts have recognized those as contract claims. That's no longer available. And the A3 should provide a viable right to participants where you have significant violations. I point out this Weizenkamp versus Unum case, which was just recently decided, principally because in that case they decided they could enforce the SPD on an estoppel theory without ever citing Amara. So again, I think that the courts will continue to recognize SPD-based claims when appropriate. The final thought really is this puts a great deal of emphasis on two things. One, making sure that your communications with your participants is always accurate, not misleading, and not nuanced. And second of all, it puts a real premium on figuring out what documents are your plan document and which ones are not. I think this will become particularly interesting in the health and welfare area, welfare plans, where you've got an ERISA wrap over a benefit statement prepared by the insurance company. I think those are still viable things that can be used, but I think you need to take additional efforts to make clear that in that case at least the SPD and the plan are the same. And with that, I'll turn it over to Greg.
Thank you, Mike. We now move to a very short refresher on some 409A principles. This is not in any sense a comprehensive discussion of Section 409A, but included in this discussion and the slides that will follow are three examples that are adapted from real-life situations we've encountered over the past few months. These examples illustrate some of the practical difficulties faced by employers with respect to 409A. So let's begin by condensing all of Section 409A into a single PowerPoint slide. 409A added to the Internal Revenue Code initially effective January 1, 2005. There was a delay period where the IRS worked on regulations. Those regulations were initially effective January 1, 2009. And existing plans had to be amended for compliance by December 31, 2008. So there was this huge push that culminated at the end of 2008. And after that, people quite naturally breathed a sigh of relief and said, we're in 409A compliance. In a nutshell, if we step back and we say, but what does 409A do? In a nutshell, 409A requires that the time and form of payment and the amount of any deferred compensation must be specified in advance, generally prior to the date the employee begins to earn the benefit. So the basic idea of 409A is that these decisions, especially these decisions about the time and the form of the benefit distribution, have to be made in advance, and that there are only limited opportunities thereafter to change. Now, the practical issue is that many people within an organization touch the compensation and benefits function at some level. For example, a manager might negotiate an executive severance agreement, but that manager isn't, and realistically isn't expected to be a 409A expert. However, the common denominator in many of these situations, when people within the organization who aren't involved in the day-to-day benefits function touch the comp and benefits function, the common denominator seems to be a desire to change things after the fact. And in particular, there's frequently a desire, either on the part of the departing employee or the employer, or both, to change the time and the form of the payment. So this leaves the HR department to function as the 409A police, so to speak, to be alert to changes proposed by others that are to be alert to changes that are proposed by others who aren't familiar with the detailed requirements of Section 409A. So if we look at example number one, that's the example I referenced earlier of a terminating executive severance agreement. There's a threshold question about what can be negotiated when an executive is terminating and severance benefits are the subject of discussion. In many cases, everything can be negotiated. Section 409A provides considerable latitude when new benefits are being provided. That is, benefits that have not otherwise been subject to Section 409A. There's no change being made to any prior benefit program. But where the agreement seeks to change the payment terms of existing Section 409A benefits or to substitute a new benefit for an existing Section 409A benefit, then Section 409A might be violated. And that's the situation that we have seen with reasonable frequency. The issue is that many executives have contracts, and those employment contracts specify certain termination benefits. If at the time of the executive's termination there is an attempt to negotiate different benefits or the same benefits that are payable at a different form or at a different time, there may be 409A issues with making that change. Obviously, we're painting with a broad brush today, and we're not going into the nuances about when it's possible to change and when it's not. But the overall comment is that if there's an existing contract, then you must be very careful in terms of making changes to that contract, and that is something that we see managers frequently missing because there seems to be quite a desire to renegotiate those at the time that the executive is leaving. Moving on to example 2. Modification to provide for payment in the same year but at an earlier or later date within that year than required under the plan terms. This is actually a very interesting thing because from a tax perspective, one might, and not unlogically, begin with the assumption that if it's all payable in the same tax year, why should the IRS care? They get their money, whether the money's paid in January of the year or whether it's paid in December of the year, the IRS gets their money with respect to that same tax year, so why should they care? And so there's built into that logical argument a belief that Section 409A is not implicated if the change does not cause amounts to be paid in a different tax year. In other words, if we only tinker a little bit, it must be okay. We recently saw this in the case of a terminating executive who had significant severance protection in an employment agreement. For whatever reason, the parties wanted to rearrange how things got paid, even within the year, shifting amounts from later in a year to earlier in a year and moving things around. So the concept that moving money within a year is okay, that concept is only partially true under 409A. Payment at a later date, but within the same tax year, does not violate Section 409A. So, for example, if your agreement says that an executive will receive a payment on June 30th and that payment is delayed and paid on or before December 31 of the year, that's not a 409A violation. Moving the opposite direction, though, to accelerate payments may be a 409A violation. Payment at an earlier date, even if within the same tax year, violates Section 409A if the payment is accelerated by more than 30 days. Example number 3, linked qualified and non-qualified plans. The situation here is an employer that maintains 2 plans. The first is a qualified pension or defined contribution plan. These plans, by virtue of being qualified, they qualify for favorable tax benefits, and therefore they are subject to additional rules and restrictions that are applicable to those types of plans. Those plans have limits, government-imposed limits, maximum benefits that can be provided, restrictions that prevent an employer from providing perhaps full benefits to certain highly compensated employees. So what the employer does is there might be a non-qualified plan, which is then subject to 409A, which overlays the qualified plan and provides the benefits that cannot be provided, provides through the non-qualified plan the benefits that cannot be provided through the qualified plan due to the government limits. The key issue here, when you have this kind of qualified, non-qualified plan structure, is how the benefits are paid. The qualified plan is going to permit the participant to make a payment election, in my example, lump sum or annuity, at retirement. That is, after the individual has performed all of the services, they're on their way out the door, they're retiring, and then they get to make an election to say, how do you want your benefit to be paid? The non-qualified plan, in this example, provides for an automatic lump sum. There is no participant election with respect to the form of payment. We recently saw this in which the question was raised, is this a drafting mistake in the non-qualified plan? And the answer is no, it's not. The non-qualified plan, because of Section 409A, may not offer a choice at retirement between lump sum or annuity benefits. If we go back to the general principle that these decisions as to the choice of time and form of payment have to be hard-coded in advance of the services being performed, you can't have that choice between lump sum and annuity benefits made at retirement. And now, this was a fundamental change in Section 409A. Previously, the non-qualified plan used to say that if you make one election, under the qualified plan, and whatever you decide there also governs your non-qualified benefit. The idea is that the qualified and the non-qualified plans were linked. And the idea that the qualified and non-qualified plans are linked is so ingrained, quite naturally, but it's so ingrained in people's thought process that it's easy for somebody who's not familiar with Section 409A to pick up a qualified and its companion non-qualified plan and to assume that the payment provisions should still be linked and that therefore there might have been a drafting error in the non-qualified plan. Not so. That non-qualified plan, which doesn't give a payment election at retirement, is intentionally drafted to comply with Section 409A. And obviously for the folks who are on the line, the HR role is to keep reminding managers who might be thinking of the old regime that no longer exists and is simply ancient history. So the moral of this little 409A refresher is, number one, be especially on the lookout for possible changes in benefit payments, particularly in the context of severance agreements where there's a negotiation ongoing at the time that somebody is leaving the organization. To the extent that that individual already had benefit entitlements that are triggered by their separation from employment, be careful for changes. And second, remember that Section 409A fundamentally changed the landscape. So if someone suggests that distributions from qualified and non-qualified plans are linked, just remember that that's ancient history. So that concludes our short refresher on some 409A principles that we've been seeing a lot of questions on. And with that, I will turn the floor over to John, who will discuss the recent Wal-Mart decision.
Thank you, Greg. Just by way of background, my practice tends to include employment discrimination and single plaintiff cases as well as wage and hour cases, but these days a very significant part of my practice, in fact the vast majority, is class action litigation, which can vary from discrimination cases to wage and hour cases to more regionalized cases to these days several nationwide class actions. At the end of the presentation, I will turn over a few comments to Mike Wolver regarding Wal-Mart and its impact on employee benefits litigation. Before turning to the substance of the Wal-Mart decision, I think it's helpful to get us in the framework of what is required under class certification, just briefly, so that we can focus in on where I think the meat of the decision lies. Class certification under Federal Rule of Civil Procedure 23A, under 23, requires you meet the four elements of Rule 23A, which are numerosity, essentially that you have enough folks to make a class action. In California, for California-only class actions, that can be a small number, arguably as few as 10. Under the federal rules, which are California basically adopts the federal standard, under the general rules of federal procedure, those can be as small as 20, 30, or 40. The Wal-Mart case, it's not an issue, as we'll discuss in a moment. The second element is commonality, which is essentially that there's a sufficient common issue of law or fact that really is the glue that binds together all of the allegations of the class members, and we will talk about that in a moment. Typicality is essentially that the named plaintiff's claims are typical of the class, that their experience isn't different in some way, and then there's the adequacy of representation. Wal-Mart, and particularly my discussion today, focuses on commonality here, whether there are issues that are common to the class. So that's where we'll be spending our time discussing. Class certification also requires under Rule 23B that at least one of the three requirements are met. Due to time constraints and also because the focus, I think, of the importance of Wal-Mart really lies under 23A. I will not get into discussion of this. I've got a few points I'll make briefly, but one of the essential elements deals with whether or not there is an opportunity after class certification to opt out of the class. Once a class is certified, will a class member essentially be able to get out of the class, do an individual suit on their own? Arguably, B2 does not require that, and B3 does. And the court ends up rejecting for monetary damages an argument that somehow monetary damages are incidental to declaratory relief, where maybe an opt-out requirement is not required, and elects for the B3 requirement, which I'm used to seeing, which is an opportunity after class certification for a class member to opt out. I will discuss just briefly here at the end the Fair Labor Standards Act, the FLSA, which is actually an opt-in process. But with that, it's really the commonality requirement that I want to focus on. So just a brief factual background. I won't read every line here on the slides, but as you can see, the class was comprised of 1.5 million current and former Wal-Mart employees in 41 regions, and you can see the vast scope of such allegations in many different locations and departments, alleging that there was gender discrimination in promotion and pay, and that there was a common policy in which local managers had the discretion to set pay within a range based on subjective factors, and these ended up favoring men through a quote, corporate culture permitting bias. So the proposed class was really all Wal-Mart store employees who have been subjected to this pay and management track gender discrimination. The evidence that was offered, and I think it's important to understand just in general terms what it was and why it was rejected, is a statistical evidence of pay and promotion disparity. There was an expert that testified as to some of these disparities, in particular at local levels, that there were in certain locations differences between the pay and promotions to men and women. There were anecdotal reports of gender discrimination by 120 female employees. And then there was sociological testimony of a culture that is somehow vulnerable to gender discrimination. And the Ninth Circuit permitted that and a random sampling of claims subject to discrimination. The general holding of the Wal-Mart case really focuses on commonality, and that it's not enough to just pose a, quote, generalized question. Instead, there must be something really meaningful, and I will focus in on what that is here in a moment. So merely showing that discretion is exercised in some way, the court notes that, you know, common sense essentially is that it would be exercised, unlikely to be exercised in the same way. So I really think the court is looking for some proof of some common way that it's exercised, and that the class has suffered some same injury. That same injury requirement is discussed under both 23A and 23B, but it's still a significant point as to whether or not it's being exercised in the same way, and in particular whether there's a same injury that's occurring. The proof of commonality can happen in a couple of ways. The most obvious uniform way would be showing some bias testing procedure, which was not applicable in the Wal-Mart case. There simply was nothing like that. Or that there was, quote, significant proof of some general policy of discrimination. The court really noted that there was no evidence regarding the percentage of discriminatory decisions that were made. There was no evidence of any common mode of exercising discretion, and there was really no common direction that could be found. There's no nationalized policy that anyone could point to that was similar in any way or outright direct that there was some discrimination going on. I will talk in just a moment about the fact that the court really focuses on a higher standard of proof for experts. In particular, the sociologist's expert testimony was essentially just rejected by the court as not being helpful. A sort of generalized opinion about a corporate culture is really not going to be enough to be of use. So the court, some of the takeaways from what the Wal-Mart court said were, look, we're going to have to look at the merits of the claims in order to discuss whether or not certification is proper. And really that goes to, in my mind, showing the reasons that the employment decisions were made. So sometimes there is discussion and argument whether or not you go to the merits when you're talking about whether or not there's a common issue. In this case, the court says, look, we've got to look at the merits to see what the reasons were. And that the expert opinions need to be carefully looked at. I won't go through what's called the Daubert standard, but it's a more scientific standard for expert opinions. And the court, I don't think outright, flat out says that you have to apply the standard, but comes pretty darn close. And in any event, says the sociological expert testimony really was not helpful. Meeting the commonality threshold will be more difficult, and you can see some of the language here. Mere violation of some provision of law, let's say Title VII is being violated, that's just not going to be enough. And in order to establish the commonality requirement and the glue that would hold people together, again, a uniform testing procedure could be a manner, but focusing on number 2 here, which is that there's significant proof that the company operated under general policy of discrimination. One of the big aspects here was that, a lot of these decisions were decentralized. Not that a centralized decision process cannot be, improper for class certification, but in particular here, the discretion has a kaleidoscope of supervisors. There's different regional policies that differed. The commonality can't be established just by merely an expert opining about a company culture. Just showing, I read Wal-Mart to strongly say that just showing even differences in pay is not going to be enough. There's really got to be some proof of some common thread of why that's going on. And even though 120 declarations may sound like a lot to some, I would argue that it really isn't, and I think the court agrees here, that in a class that really only works out to a small fraction of what the class members are, and it really isn't proof of some significant proof of general discrimination, and you can see that the court is looking closer at the merits here and whether or not it's really going to get past that threshold of showing some common issue of why and how. So I know we're running out of time here, but there's got to be, convincing proof of some uniform policy. I'm going to skip past 23B right here. As I said, it goes to a little bit of a different aspect of the case. But one important aspect is the last bullet here on this page, which is that sampling and quote trial by formula is rejected. So the Ninth Circuit approach is really to sample and give back by multiplying this average in a very, in my view, a very estimated way. And the court is saying, no, we're going to give the defendant an opportunity to look at those individual, even at a later stage, those individual determinations and eligibility for that back pay. So we're really looking at a much more specific manner of proof and of showing that there's some common thread. Very quickly here, I'd like to leave a couple minutes for Mike to talk about the impact on employee benefits. There is this just sort of sums up some of the key defense arguments about decentralized decisions and not a national decision-making process, the same sort of injury, and that really the proof is going to have to be much more specific as to the type of injury and how it was caused. I would make a final note that, as I said, a significant amount of my practice deals with, for example, wage and hour litigation. And while those cases involve just independently, I think, theories that lack merit and are not suitable for certification, including ones that I'm involved in right now, I would note that a focus I expect to see is an argument trying to focus on a very specific uniform practice, maybe even in a more localized way. And under the FLSA, even though it's under 29 U.S.C. 216B, sometimes courts say that Rule 23 applies, but even if it doesn't, I think the principles definitely will apply in terms of showing that there really is, and to use some of the words out of FLSA cases, the disparate factual employment settings of the plaintiffs, these are really synonymous with the commonality requirement. And in fact, there is a recent case of the Eastern District of Pennsylvania that says, yes, under the FLSA, sometimes in certain jurisdictions there is what's called this two-step analysis. There's an initial sort of easier, arguably, manner for conditional certification, but we think that Wal-Mart is going to apply, and in particular at both stages, but in particular at that second stage when in FLSA litigation, when a defendant is trying to decertify a class. And so I think that the Wal-Mart case is definitely going to apply in a significant way to even FLSA cases. And with that, I will turn over to Mike for a few comments on employee benefits and how Wal-Mart will affect those kind of cases. Mike?
Thanks, John. Again, as John just pointed out, the whole focus of the Wal-Mart decision was on certification of a class under Rule 23, and the whole analysis of Wal-Mart doesn't really, in terms of the legal standard, applies generally to all kinds of classes, including people seeking to certify classes based on violations of ERISA. And all of the big cases that you see, like Cigna with a class action by employees, currently there are a large number of class actions that have been brought against insurance companies, alleging violations under ERISA. So Wal-Mart will be an important case on the ERISA side of things as well, to the extent it guides how you have to, what hoops you have to go through to certify a class. I think in the Amara context, I think there are two issues that people are focusing on. First of all, commonality in terms of everybody having the same harm. If you think about Amara, which is a conversion from a DB plan to a cash balance plan, the only people really harmed are the people who are subject to wear away, and younger short-term employees may actually accrue benefits faster under a CB plan. And the class in Amara was all employees. So if the harm is the failure to give the notice, that's one thing, which the Supreme Court may have suggested. If the harm really is a harm under the terms of the plan, then commonality could certainly be an issue going forward. The second thing in Amara that people are focusing on the ERISA side is the language dealing with certification under 23B2, which is again the equitable relief or injunctive relief standard, which is exactly what Amara was certified under. The court clearly says that basically if you're going to have monetary relief, you need to do that under B3. Whether that really is the rule in an Amara type context where basically everybody is going to get a standard benefit, even if an actuary has to compute it, whether or not that is an individualized award or not, that's really an issue that we're going to have to deal with down the road. And with that, I'll turn it back over to Lee.
Well, thank you, Greg, Mike, and John, for your presentations today. They were very interesting and helpful. If you have any follow-up questions, our contact information is on the slide. Our final quarterly webinar of 2011 will be coming up on October 25th. We'll be sending out invitations for that as we get closer to that date. And we want to thank you for your time today and for being with us. Again, if you want to print out a copy of this PowerPoint presentation and you didn't do so today, it will be available on our website within the next 1 to 2 days. And as always, we welcome your feedback, your comments on this presentation, your ideas about any presentations you would like to see in the future are very welcome. And there is a link to the feedback page where you can give us those comments. Hope everybody has a wonderful day and a good rest of the week.
Ladies and gentlemen, that does conclude today's conference. Thank you for your participation and have a wonderful day. You may all disconnect at this time.